I want to go back to October 11th's activities. After being asked 3 times by Department of Justice Attorney Stu Evans, the FBI finally responds, quote, that Steele had been paid to develop political opposition research. In your report, you write that Strzok has advised Page support from McCabe might be necessary to move the FISA application forward. Strzok texts Page, currently fighting with Stu for this FISA. The following day, Lisa Page texts McCabe, I communicated you and boss's green light to Stu. I communicated, I think it's your, and boss's green light to Stu earlier. I've not heard back from Stu in an hour. I will invoke your name to say you want to know where things are. Isn't that pretty high-level pressure on Stu Evans by Peter Strzok, Lisa Page, and Andrew McCabe?
There was certainly that effort, exactly as you described. What ultimately happens is McCabe speaks with the head of the National Security Division about it, so they ultimately don't need to do what they're talking about here. But that is absolutely what they're talking about.
I want to go back to pick up a little bit what Senator Langford was talking about with Bruce Orr. These are quotes in your report by senior Department of Justice and FBI officials describing Orr's ongoing interactions with Steele and the FBI. And these just basic descriptions of how these officials thought about it. Quote, outside of Orr's lane, they were stunned, they were uncomfortable with it, out of the norm, bad idea, raised red flags, flabbergasted. FBI should have alerted DOJ. Shocking, inconceivable. That's, again, those are a lot of senior Department of Justice FBI officials. What was interesting is how Andrew McCabe responded to Orr's activity. He said, this is a responsible thing to do. How do you explain that discrepancy from most of the FBI and Department of Justice officials and Andrew McCabe thinking, not a problem, it's a responsible thing to do?
Yeah, look, I can't explain why that view would be there. I think it's perfectly understandable why, if you are in the Deputy Attorney General's office, whether you're the Deputy Attorney General or right below the Deputy Attorney General, to have someone on your staff doing what was going on and not telling anybody is highly problematic. And as we point out here, the net result of that is the Deputy Attorney General was signing a warrant that did not include key information that someone on her staff knew and had told the FBI, but the FBI had not come back and told the Justice Department. That was the net outcome of that. That's a problem.
Well, again, I'm seeing Andrew McCabe's fingers all over this thing. I'm also seeing him saying can't recall 26 times on significant issues. I'm not buying it. Let me go back to State Department involvement. I realize that you're limited, but I just want to ask some questions. Are you aware of why high-level State Department officials meeting with Steele and forwarding his reporting to the FBI? Why were they?
The only thing I can say is from speaking with Ms. Kavalek, it was because she thought she had to tell them because they needed to know. But as to the others, why they were doing what they were doing, I don't know the answer.
Did you obtain any information, meeting notes, or any other documentation based on those meetings and contacts?
We obtained certain information from the State Department, including, for example, Ms. Kavalek's notes, and we were able to speak with her.
You did request interviews with Jonathan Weiner, right?
Correct.
Do you know why he refused to cooperate?
I don't know.
Why did you want to interview him? What information did you feel he had that you wanted to know?
Precisely because of his interactions with Mr. Orr and Mr. Steele, much like we went to talk with Ms. Kavalek, because we wanted to tie off an understanding as to what was happening between the Justice Department and the State Department.
On September 30th, 2016, Peter Strzok texts Lisa Page, quote, remind me tomorrow what Victoria Nuland said. Did you ever find out from Lisa Page what Victoria Nuland had told her somewhere on or about September 30th?
I don't recall as I sit here whether we heard about it. I'd have to follow up with that, Senator.
And Senator Peters, let me just talk a little bit about whistleblowers. You know, I would share, Senator Peters, I think everybody on this committee, and your desire to afford those whistleblower protections. There's no doubt about it. It's vital. I'm shocked, quite honestly, coming from the private sector, the level of retaliation against people to come forward. But I do want to clarify the law. As Inspector Generals, you are by law barred from providing or basically blowing the confidentiality, identifying whistleblower. But the statute actually does contemplate if somebody's accused of something by a whistleblower and they're in a court of law, it actually contemplates the person being accused being able to confront his accuser, correct? The whistleblower?
It basically says by operation of law. So it'd be up to the judge to make a consideration of that. But certainly, if it was in a criminal case and you intended to rely on the witness would have to be there. What you would try and do, in police corruption cases, I've had this issue, and you have some people willing to come forward and some people not willing to come forward. And if they're not willing to come forward, you've got to figure out how that information, if possible, and it not always is, if possible, can be translated into the federal rules of evidence allowing that information in a courtroom.
But again, there's not absolute statutory protection in terms of whistleblowers' confidentiality.
No, the statute, the IGX says we have an obligation to keep it unless the law requires us to do otherwise.
I just want to kind of tie up a few loose ends here. I've got a lot of questions, which we will submit as questions for the record, and we'd appreciate to be responsive on that. Real quick, going back to the Bruce Orr activity in terms of being a conduit between Christopher Steele and the FBI. Peter Strzok, in your report, has handwritten notes, which pretty well demonstrate he knew about Orr's activity, and yet in his interview with the Inspector General team, he denied that he was aware of what Orr was doing. Are you buying his denial?
So I'd have to go back and frankly refresh my recollection on the notes versus what he told us. I'd want to just double check on the breadth of what he knew, because Bruce Orr having 13 meetings, he clearly knew, for example, about the Manafort-related meetings because he was at some of the Manafort-related meetings. So I just would need to
we'll put that in questions to the record. I do want to talk a little bit about monitoring or surveilling the, what is the euphemism? Consensual monitoring. In other words, you're wiring somebody to surreptitiously record someone associated with the Trump campaign versus the Trump campaign. I think it's a difference without a distinction, but there's a distinction because there's a difference in terms of what authority, what approvals the FBI would have to get, correct?
Correct. That's the reason for the distinction, but I agree with you. There's varying degrees here of what occurred.
So they were trying to be pretty scrupulous about saying, oh, we're not surveilling the campaign. We're just surveilling people associated with the campaign.
So what ended up happening here is, as you said, and we'll try and what they did was they took individuals, informants that were signed up informants for the FBI, wired them up so they could be recording conversations they had without the person they were speaking with knowing that they were being recorded. That's, in essence, what a consensual monitoring is.
Sounds really
One party's consent.
Really sounds really close, like you're monitoring the campaign. But again, just lay that aside. That's my own personal opinion. Did you ever determine why the FBI changed its opinion? I think early on when they interviewed, and again, this was not exactly done above board, but they interviewed Michael Flynn. At that point in time, I think the agent did not feel that Michael Flynn was, dishonest with him. Somehow that changed. Do you have any idea why that opinion changed?
I don't know. I've heard that, but we actually have no insight into what happened there on that case specifically.
Quick follow-up on Senator Paul's line of questioning, and we spoke about this a little bit earlier too. There really are a lot of controls in current law that, had they been followed, the Woods procedure, other requirements that the FBI, and everybody knows this, they have to be scrupulously accurate. So there's plenty of layers of control over this FISA application, correct?
There are a lot of layers of control.
And I realize your limitation, you can't really recommend legislation. You have to kind of stay within your lane of the Justice Department, but do you really think another layer of controls is going to fix this problem? Because this was caused by people circumventing.
Right. There are certainly some controls additional controls that could help. For example, on some of the informant activity and others. With regard to the FISA, I agree. I think there's, and this at the hearing last week and this week, real questions about does there need to be legislative activity here? And of course, there's also now the FISA court has put out its order, and they're going to have some involvement, obviously, in a significant way in that decision-making as well. That's well beyond the executive branch figuring out what
I mean, my own personal opinion, for somebody who has definitely supported the FISA court, largely because we were told, well, show us where their abuse has been. That these applications are approved at such a high level because it is so rigorous. It is so scrupulously accurate. Now, that's been completely blown. I think the FISA court is in jeopardy, personally. And I view that as a very serious issue in terms of our national security. So I think it was James Langford talking about that. So I agree with his concerns. Final two questions really speak to the limitations that you have in terms of conducting an investigation like this. So real quick, who couldn't you investigate? I mean, or what couldn't you investigate? Who couldn't you talk to? That if you'd been able to, you would have been able to tell a fuller story here? Because there's still a bigger story to be told.
So our review, as we made clear here, is about the Justice Department and the FBI's handling of the opening of the Crossfire Hurricane investigation and the Carter Page-related FISAs, along with the FBI's activities on their confidential human sources and surveillance that the FBI did. We did not go and look at or try to assess allegations about what the State Department
so you would kind of like to have known that, right?
Well,
but you can't. You couldn't do it.
We certainly wanted to know from the State Department side, which is why we went to Mr. Weiner, what Bruce Orr and Mr. Steele's activities were with them. What we weren't trying to figure out is separately what the State Department might have been doing on their own or their own interest, if they had any. I don't know, as I sit here today, if they have any. People have asked questions about what did other intelligence agencies know. If that information was sitting in the FBI's files, we had access to it. If it's something they did separate and apart from the FBI, that was beyond the scope of this review.
But you'd kind of like to know how George Papadopoulos met all these individuals that just happen to be connected in different ways.
I think you'd want to, it would be interesting to know a lot of pieces of information that are strands here. I don't necessarily believe it would have, well, based on the access we had at the FBI and the information we had at the FBI, in terms of the FBI, what affected the FBI's decisions, I have no reason to think there's something else out there that we didn't see.
Okay. This is very similar, but what other big questions are outstanding?
Well, it depends. At the FBI, I'm not sure what other questions are out there other than what I mentioned earlier, which is how did all of these failures in the FISA process that's layered with all of these controls happen and why? And I know that's a big question for people to know an answer to, and I understand why. But you know, at this stage, that I think we didn't get good explanations about, and that was something we frankly would have liked to have gotten good explanations about.
Well, again, I want to thank you and your team for really an extraordinarily good piece of work here. Understand the limited nature of the scope. We will be providing additional questions for the record. We've obviously been looking for this to guide our actions. And one of the reasons I've asked those last two questions is that would also help guide our future oversight as well. You are obviously steeped in this. You have the details. So I would just ask your entire team, you know, who else would you want to have interviewed that you didn't have access to? What other questions do you think remain? And I'll just kind of throw that as an open-ended question for our questions for the record.
Okay.
But again, I want to thank you for your integrity, for all your hard work and efforts. This is unbelievably important, what you've revealed, and we've got a lot of work ahead of us. Yep. Senator Peters, you want? Okay. With that, the hearing record will remain open for 15 days until January 2nd at 5 p.m. for submission of statements and questions for the record. This hearing is adjourned.